The Honorable Alfred Chianyeboa is the Deputy Attorney General. He's joined me on the line now for more on James Gyakye Quayson. Honorable, you're welcome to Eyewitness News.
Thank you very much, my brother.
First of all, I do not understand this bit where the judge says she's going to make the MP cross-examine the prosecution witness himself. Is it the case that the lawyer has gone AWOL?
Thank you very much. Let me put this in the proper perspective. PW1, who happens to be our first witness, has been in the witness box since 12th of July 2022. So for over 1 year, 16 days, a simple cross-examination that the counsel for the accused person said was going to use 2 hours to do has taken us such a period. To the one who went to court, counsel for the accused had sent a letter to the effect that he was indisposed and had been given 3 days exclusivity. That exclusivity is dated 27th yesterday. And we know that the courts will be going on vacation by the close of Monday, 31st of July. So I made a point that you can't have one witness being in the witness box on 3 different legal years. Because remember, July last year belonged to the previous year's legal year. Then we started last year's legal year. Then we want to take him to the 3rd legal year. I mean, it's not something reasonable. So the judge, in her wisdom, said, fine, she may want that cross-examination of the PW1 completed. For that matter, on Monday, we should be in court. Fortunately, on Monday, the accused person's counsel paid the excuse duty will have resumed work. And that's why the judge added that if counsel for the accused person does not show up, she may want the accused person himself conduct the examination.
Okay, now this means that whether or not the lawyer appears, the accused person will have to cross-examine the PW1.
Exactly.
Prosecution witness one. But
yeah,
why would you subject a person who is in court to do cross-examination when the person has paid a lawyer to do that for them, and they possibly don't have the legal prowess to cross-examine?
This is not the first time, my brother. You can check from the courts. It's done daily to either accused persons or parties in civil litigation. The judge may tell you, if your lawyer doesn't show up, I'll ask you to continue. It's not the first time. I mean, this one has been in existence for a very long time. So the judge only just informed him about that decision of his. But Monday is 31st, and based on what we were told today by counsel for the accused person, he will be in court for us to continue hearing the matter.
The issue of adjournment and what I've seen in the court, usually there's a proposal from the lawyer after they go through their diary and they check with the prosecution and the date is agreed, which date is now communicated to the judge who then either accepts or asks for another date. There are times you hear a lawyer say, I have another case in another town, I will not be available on this day. Prosecution may say something similar. The judge may not be available. You agree on a date. How come this time around the proposal was made for the next legal year by the defense team, and you opposed to that, which opposition was accepted by the court?
Yes. Counsel at times agree on a date, and subject to the convenience of the court, that date is taken by the court. But that doesn't mean that whatever agreement that both counsel agreed on, the judge is bound to take it. Now, in this particular case, counsel for the accused person suggested a date in either October or November. And I saw that suggestion as being very unreasonable in the circumstance that the PW has found himself in this particular case. That's the reason why I said no. It was my view that since we have one more day to end the legal year, we will have to take advantage of it.
So it must be on Monday.
That is the order the court made today.
I know that the High Court has given you the permission and said that the court will hear this Gyakye Quayson case on a daily basis. There are political ramifications to that because members of parliament on the NDC side have decided to not be in Parliament any day he's invited to the court. This is hampering the work of government which has to go through Parliament. You are not in Parliament, but you are the government's prosecutor general as a deputy. How do you hope to get out of this political quagmire where you have challenges in executing governance in Parliament, and yet you are prosecuting one single case? How important is James Gyakye Quayson's trial? For which reason everything must grind to a halt, and why must there be daily trial for him? And critics have said Nana Appiah-Mensah was arrested, has been standing trial forever. Several other persons have been mentioned. People who even killed members of Parliament allegedly are not having to have daily trials. Why is the state interested in trying James Gyakye Quayson on a daily basis, regardless of the consequence?
May I also ask a rhetorical question? Why not? Is Mr. Gyakye Quayson above other accused persons whose cases are also heard on daily basis? That's the key question. Is it the fact that if you are an MP and the court decides, which is another arm of government, that is going to hear your case on daily basis, the court should stop it? In any event, since that order was made, you can check over the last 2 months whether we've been to the court for hearing more than 2 times in a week. At best, we go to court once a week, because the judge has made it clear to all the parties that the fact that she had ordered that the case will be heard day to day, but doesn't mean that every day, because there may be other circumstances. For example, when in court today, counsel for the accused person brought a letter that is indisposed. We couldn't go on. We will go to court another time, Mr. Gyakye Quayson himself, or even from our side. So it doesn't mean that it's cast in stone and iron. It's something that is done in all the other courts, most of the other courts. Go to Tamale, and those who listen to me in Tamale, you may have some cases there that the judge, I know one of the courts, the judge has been hearing the matter from Monday to Friday, 5 days, every day. Why is that person not complaining? Is the person not a Ghanaian? The person also not contributing to the development of Ghana? I believe in equality before the law. I also believe that an MP must perform his duty considered. But that does not mean that if an MP is involved in a matter, he must be in a special dispensation different from the farmer. Because the farmer is also a citizen and a Ghanaian. He must also work.
Okay, but it still does not explain the other part. These cases you talk about, which are heard on daily basis, they do not affect the work of government in Parliament. This particular one is. Are you not bothered?
It's a problem a bit if you have other members of Parliament saying that they may want to follow their colleague to Parliament at their court on each court date. If you want to go along that route, I think it's quite unfortunate, because they also have their responsibility to discharge in Parliament. They may want to solidarize with him, no problems with it, but that does not mean that if the court decides that the case should be heard on a specific date, because that order has been made, we should not go on. It's a border, but we must also go on. One arm of government should not wait for the others. There must be a cooperation. The cooperation is that the court has given the indication that day to day, but it's not cast in stone.
When the NDC says what you are doing is persecution and not prosecution, because the gentleman was re-elected, his people like him, and that you should drop what you're doing because you are simply, persecuting NDC MPs in the House of Parliament, what would be your response to that?
I would say that argument is very weak. If you are saying that someone has won elections, and because of that, he should be prosecuted for offense that he committed prior to his election, then you are opening the way for others to also commit crimes, go stand for elections, win, and then raise that one as an insurance flag. So as a developing country, we are developing our laws. We must make sure that if people commit crimes, they are taken through the due process. People should not use their position as insurance against prosecution. If you win elections and proud to the winner of that election, you've committed any crime, don't be expecting that because you've won, the state, regardless whichever party may be in power, should just discontinue the case. No.
The Attorney General's department is not new to making concessions and analyzing issues and deciding where to let go and where to prosecute. In fact, there is law that gives you the power to drop a charge against a person without even explaining, the nollie prosequi. You've been begged by NDC MPs, including the High Court judge, to exercise that right. You have not. But the question that would arise is that why do you have to continue in that manner? Even if you don't have to drop the charges against him, you can make it lenient for him so that he can proceed to do his work in Parliament. You can also proceed to get your work done in Parliament, and then you can continue with the prosecution. Are you suggesting that nollie prosequi is off the table, this prosecution will continue?
Nollie prosequi is not something we've considered, unless maybe later we may want to consider it, because we not found a basis to enter nollie prosequi in this particular case. You spoke about begging. I've never heard any member of the NDC begging. It's about ordering. That's the difference. If your client is taking to court as a lawyer and realize that your client, you may want to take another step, whether to take advantage of a plea bargaining act or any other step. Is it by resort to ordering the state to don't do it, do it. If you don't do it, A, B, or C? No. So it's our opinion that if it becomes necessary for the attorney to activate his powers to enter nollie prosequi, it will be done, or to withdraw the charges. But as we speak now, looking at where we got into, the evidence that we have, we don't have any basis to enter NP in this particular case.
Very well. Before you go, I spoke to you recently about someone who was working with the now defunct Capital Bank, Emmanuel Atoyesian. He was found guilty by the court, but there was a rule that the parties came under where he was supposed to make some payments to the state. It emerged that that payment was not done, and the state went back to the court and asked that he be jailed. Do you have a brief on the status of that case as we speak?
Yes. We were in court yesterday for the court to ascertain from whether he has paid the outstanding sum. Unfortunately, or fortunately for him and unfortunately for us, the judge did not sit yesterday. For that matter, the case has been adjourned to the 12th of October.
Very well. We'll wait to see what happens then. Thank you so much for speaking to us.
You're welcome, my brother.
That's Honorable Alfred Tuanyeboa. He's a deputy at the Attorney General's Department. So he's a deputy Attorney General and Minister of Justice.